how fortunate am I to have Lonnie Coombs, one of our lead anchors here, who was a district attorney in LA County and actually was on staff at the time that all this was happening, right?
That's right.
I'm so fortunate to have you here to talk about this, A, because you were there at the time, and B, because you were such an accomplished DA there for so long. You just heard my exclusive interview with the DA there, and I have to say, I thought he gave an excellent press conference, very well prepared, and we saw earlier that I asked him when I interviewed him several months ago, did he have a position? Could he give me any idea where he was headed on the Menendez brothers case? And all he said back then, as we all saw earlier, was these are actually two separate cases. What do you think about his approach to reviewing this case?
I have to tell you, Dr. Phil, I was so impressed and so relieved, honestly, because I had been feeling very uneasy about how the previous DA had been handling this case. And I kept wondering, where's the thorough research being done here before you just throw out your opinion here? And he took his time. He read over 50,000 pages of trial transcripts. He talked to all the prosecutors, the defense attorneys, law enforcement. He talked to any family member of the Menendez family that wanted to talk to him. He said he'd spent about 3 hours with them. So he really did a very thorough investigation and review of all this. And then when he did that press conference, Dr. Phil, I was watching it live because we were covering it live here on Merit TV, and I was just saying this is a master class in a closing argument. And he was literally letting the public know exactly his thought process, very transparently, as to why he got to where he was. And instead of talking about what's sort of been, you know, in the TikToks and the documentary, he went back to the facts, the law, and the analysis, exactly the way a prosecutor should.
This happened in '89, so we're talking about over 30 years here that this happened. And he reminded people that what happened here is these two young men went in with shotguns and shot their parents not once, not twice, not 3 times, not 4 times, with very powerful weapons, shot them at least 12 times, including headshots. So when you go in and shoot somebody over 12 times with shotguns, this is a heinous crime. And he talked about how they shot the father in the back of the head, then shot him in the kneecaps after he was dead, and then the mother was lying in the floor moaning in agony, and they shot her point blank in the face.
After reloading.
So even if you've got 2 shotguns, they had to reload. And the reason I'm making a point of that is psychologically, that gives you pause. You have to stop, wait, and then they also picked up every single shell, which they then took away. So there was a lot of thought here. Look, I know that a lot of people have jumped on the bandwagon and get that, and make up your own mind, that's fine, but let's remember what happened here.
That's right.
They came in and shotgunned their parents at least 12 times in a really brutal fashion.
And if I can just share with you, back at the time when this happened, I remember the detectives talking about it. They said that there was brain matter dripping from the walls. It was the most horrific crime scene that most of them had seen, and it was staged. It was purposefully staged to look like a hit. So they had done the research to figure out what does a hit look like, and to do that, and this is our parents that they're doing. And just think as they were going back and picking up those shell casings in the midst of what they had just done to their parents, I mean, that's the kind of mindset we're talking about here.
Yeah, and we're looking at some of the pictures from the crime scene at the time, and listen, they're really hard to look at, and we're being careful with what we show because we don't want to just get terribly gory here, but this was a gruesome crime. And when I talked to the DA, he reiterated that there were 3 different tracks that they could go down in trying to get out of prison right now. And one was a habeas petition to get a new trial based on new evidence. And then you could get a petition for clemency, which goes to the governor. And he doesn't have to really review any evidence. He can just say, I've made a value judgment that they've either been rehabilitated or have served enough time or whatever, and can just grant clemency. That's just a value judgment. And then third, a resentencing to get released or put on parole by having the court change their sentence, right? Because right now they're life without parole. They could change to life with the possibility of parole, and then they can get a parole hearing and they could decide, okay, they're rehabilitated, they've done well. And you heard me ask him in the interview, you have to make a decision as DA whether you would support the habeas petition or resentencing. Was this a close call? And he said this was not a close call. What was your interpretation as a prosecutor? Did you agree that this was not a close call? $36 trillion. That is the U.S. debt, and it gets deeper and deeper by the day. Our debt has never been higher, nor have the stakes. The government is looking to slash the federal budget by $2 trillion, and no one knows what that will mean for your job, savings, and future. I've seen a lot in my time, and there's one thing I know for sure. You need to prepare before it's too late. I trust Preserve Gold to help protect my wealth, and I strongly urge you to do the same. They are the only precious metals firm I trust and recommend to my family, friends, and audience, and they have a special offer just for you. Text Dr. Phil to 50505 to get your free precious metals guide from Preserve Gold. With gold prices recently breaking records and analysts predicting this trend to continue throughout 2025, you cannot afford to wait. As a bonus, you can get up to $15,000 with a qualified purchase from Preserve Gold. So don't wait. Text Dr. Phil to 50505 today. Did you agree that this was not a close call?
Yes. Yes.
Why?
Okay, so he's talking about just the habeas right now, which is the motion for a new trial. A motion for a new trial is very hard to get in any case. You have to come up with new evidence that shows that if they'd had that evidence at the time of trial, it could have changed the outcome of the case. And it has to be credible new evidence. Now, they have already made these motions previous times, multiple times, to the California Supreme Court and to federal courts and been denied over and over again. And as Nathan Hochman pointed out, he said a number of these same arguments are being made now, but these two pieces of new evidence that he brought up, the letter that was supposedly written by Eric to Andy Cano talking about this alleged abuse by his father, and then also this new alleged witness, this person who came forward and said, I was a boy band member and Jose had also assaulted me. Now, he kind of pushed that aside very quickly because it wouldn't really be admissible in the trial because the two men did not know about it at the time that they shot and killed their parents, and it would have gone to state of mind evidence. So that's kind of out. But he really talked about this letter, and he really attacked the credibility of this letter, which I'm so glad because, you know, DA Gascon was asked about it. He just brushed it aside and said it doesn't really matter. But for this motion for a new trial, of course, it's extremely relevant because that is what it's based on, whether this letter is credible or not.
Well, in order for new evidence to be, it has to be timely. It has to be admissible. So it has to meet the standards of admissibility at trial, which we'll talk about in a minute. It has to be material. So this can't be some detail somewhere. It has to be material in that you would reasonably conclude that it would have an impact on the jury's decision-making process. And it has to be credible. And I got the feeling that the DA didn't feel like it met even one of those criteria. And it would have to meet them all, right? And it certainly wasn't timely.
No.
Why was it not timely?
So the first time we even learned about this letter was in 2015, years after the trials. And at that time, it came out in an interview done by Barbara Walters. Well, if they found out at that time about it, they should have presented it at that time for a motion in front of the court asking for a new trial. But they waited almost a decade later.
It was 8 years later.
Yeah, yeah.
And so the question becomes, why would they sit on this for 8 years if, in fact, it existed?
And if it was truthful, yeah, if it's real.
Yeah, and admissibility. What's the question about admissibility?
Well, it has to be truthful. Now, at the time of the trial, Eric testified in both trials about sexual abuse. Andy testified in both trials about sexual abuse. Now, they're both getting cross-examined really hard on if they're being truthful or not. If they had that letter at that time, they could have said, look, I wrote this letter months before we killed our parents, talking about this. That would have gone a long way to support what they were saying. Neither Eric nor Andy ever mention the existence of that letter in trial.
Okay, so maybe one of them forgot about it, but both of them forgetting about it, both
There's
of them
no way.
forgetting that they had written this letter. And where's the original?
That's right. We don't know.
And so this is a photocopy. And a photocopy, you can't come in and age the ink. You can't identify the paper. You can't do anything to determine whether it was written at the time.
No, you can't. You can't authenticate it.
So there's no way to authenticate it. You got to have the original, which they didn't have. And they did testify about this. Does it materially add to what was presented at the time? And the lawyer for Eric at the time said, we're not taking a position that if there was sexual abuse, that it justifies the crime. She said, we're not taking a position now, nor will we ever.
Right. What she's saying is, and this is the law, sexual abuse, if it was true, is not a defense to murder. You can't just say, oh, I was sexually abused, I'm going to go out and murder my abuser now. That is not the law. It does come up, and they did argue it as part of a imperfect self-defense, which is how the defense got to arguing for voluntary manslaughter, okay? It's not a real defense, it's imperfect, meaning that they had a good faith but unreasonable belief that they were going to be in imminent danger, that their parents might have killed them.
Right, but for real self-defense, you have to have a state of mind that you are in imminent danger,
Exactly.
immediate danger. It's going to happen if you don't do something to stop
That's
it.
right. And other people, reasonable people, would agree with you. Hearing what your circumstances were, yeah, I agree, you were in danger. That's what self-defense is.